We continue the laws of marriage. Chapter 20. So, I'm going to speak about a dowry. Our sages decree that a man give a certain portion of his holdings to his daughter as a dowry. This is referred to as parnasa. When a man marries off his daughter, he should provide her with at least a wardrobe that is given to a wife of the poor Jewish man, as we've explained. At least that. In other words, you got to set up your daughter in life. That's what it means, right? When does the above apply? When the bride's father is poor. If he's wealthy, he should provide for his daughter according to his standards, right? So in other words, it's not enough just to marry off your daughter, but you have to provide for things. Today, there's a lot of organizations, Achnasas Kala, helping a bride to get married, and so they can have, kitchen stuff, beddings, clothing. Hmm? Hmm? Fine. Right. Yep. So yeah, it costs to marry off your daughter. Baruch Hashem. And we're blessed to marry off 5 of them. All of them. Okay, halacha number 2. If a father explicitly tells a prospective husband that his daughter does not possess anything, and that his intent is that he marry her although she does not possess a wardrobe, the bride is not entitled to anything of her father's. Others, this is what a father should do, but if he's going to tell the prospective husband, take her as she is, so in such a situation, the prospective husband should not say, when she comes to my home, I will provide for her a wardrobe. Instead, he should provide her the wardrobe while she's still living in her father's home. Remember that a guy and a girl get engaged. Engaged means they're called married. Well, I don't know if engagement, we should use that term. It's called kiddushin, right? Yesterday, I was at a wedding. I was giving a class by the wedding. I'm in the car going to the wedding, and then by the wedding, waiting for the chassan to come out to the chuppah. So I was honored with giving the blessing, reading the Rebbe's letter and the blessing, and I was also a witness. So why am I saying that? It's the reason why I said that. In any case, I'm certain why. All these things need to be provided in advance. Oh, so a witness, I mentioned that today we do the 2 parts together. Kiddushin, which is the ring part, and then the Sheva Brachas, the 7 blessings, which is the like creating a home part and making the blessings over of creating a home. Both are done under the chuppah, which the chuppah is marriage canopy. That marriage canopy represents like a home, creating a home. And then afterwards, they are in a private room that, as a witness, me and the other witness had to check the room to make sure no one's in there. Right? Good idea. Right? And no one is in there, only the bride and the groom, because their seclusion is part of creating the home. Because a home is a place where you have privacy, right? There's a privateness between the couple. So in any case, so all those things need to be provided in advance. Either the father is doing it, which is the appropriate way. When it comes to the wedding, all I do is, write the check. That's my job, right? That's what it means to provide. Write the check. My wife and daughters, or my would, get whatever was necessary. So thank God, God was good and is good and provides. So all this needs to be provided in advance. Okay, when a father dies and leaves at least one son and a daughter, she is provided with a dowry from his estate. We estimate what the father would have desired to give to the daughter as a dowry, and she is given that sum. How is it possible to arrive at such an estimate? We survey the habits of his friends and acquaintances, his business affairs, and standard of living. If he married off a daughter during his lifetime, we base our estimate on what she was given. If the court is unable to determine what he would have desired to give his daughter, she is given a tenth of the estate as a dowry. I'm assuming that's a large estate. That's quite a lot to give a tenth of your estate as a dowry, right? Wow. Yeah, it doesn't seem like necessarily there's a view that. Oh, definitely, I don't think that's what's done today. Okay, when a man leaves a son and many daughters, the first daughter who desires to marry is given a tenth of the estate. The second daughter who is married receives a tenth of what is left from providing the first daughter of her dowry, and the third daughter receives a tenth of what is left of providing the second daughter. Right, so the tenth becomes less and less. If all of the man's daughters come to marry at the same time, money set aside to them according to the above pattern. Even if there are 10 daughters or more, afterwards all the allotments are pooled and then divided equally among the daughters. The remainder of the estate is given to the sons. The daughters get first dibs. The allotment of a tenth of the estate as a dowry is not one of the provisions of the ksuba. Right. So, but the marriage contract, right? Because the marriage contract, this is the daughter now, right? So the marriage contract is what the husband has to provide for his wife if he dies, or from the estate, or if he divorces, right? So it's to the wife, and by extension, it goes to the children. But the allotment of the tenth of the debt for the dowry is not a provision of the ksuba. Therefore, even according to the enactment of the later sages, it is only to be collected from landed property, right, as opposed to money, as opposed to movable property, right, or money. Right. So when we are estimating the value of the estate and we're saying a tenth, it means only landed property. It does not mean possessions. Right. So if he owns, a few gold bars, those are movable property. That's not called landed property. Right. It may, however, be collected from rent due for landed property. Right. You lease out the land. If, however, the girl's brothers desire to give her money in lieu of a tenth of the landed property, they have the right. So instead of giving the actual landed property, they can keep the property and give the value, the brothers. With regard to this allotment of the tenth of the estate, the daughter is considered to be a creditor of her brothers. Right. Therefore, she is entitled to collect it from property of intermediate quality, and oath is not required of her. previously you had to take an oath. The wife had to take an oath for when she wanted to collect her ksuba, because maybe she sold her ksuba, right? Or maybe she made it null and void the value of the ksuba, right? Remember, this is for her protection, but she decided whatever, for whatever reason, she did that, right? So she'd have to take an oath. But here, you don't have to take an oath because we're talking about a dowry, right? That is a responsibility from the estate. So it's, I annulled my dowry or I sold my dowry, you weren't engaged to sell anything. So you don't have a dowry inherently, right? If her brothers die, she's entitled to collect it from their sons because now it goes to the son's sons, right? Our inheritors. Expropriating property of inferior quality and an oath is required of her. That's interesting. Why? Because that she has to take an oath that she didn't receive any of the property yet. To the brother, her brother, she doesn't have to take an oath because the son, the brother, got the property, right? So if he's going to say, well, I gave you, so then that's going to be an issue in the court of law, right? But the brother, who's the son of the father, the brother to the bride, right, who's to get the dowry, her brother died and had a son who now was his inheritor, right? Well, he doesn't know the business, what went on. Did she get, did she not get? He wasn't involved in it. That's why she has to take an oath that she didn't receive already from the property towards her dowry. Is that clear? But she's collecting property from heirs and is accepted principle that a person who comes to collect property from heirs may collect only from that which is of inferior quality and is required to take an oath before doing so, as will be explained in the laws of loans. Hmm. 7. Should her brothers have sold the landed property of their father's estate or given it as collateral, the daughters may collect her dowry from the purchasers. Right? All right. She's got a lien on it. Just as other creditors are entitled to collect from the purchasers, as we explain in the laws of loans. Okay? It's interesting that she has a lien on it. I find that interesting. Okay? Okay. Okay. When a man has several daughters but no sons, his estate is divided equally among the daughters at the time of his death. Although he married off the older daughters during his lifetime and provided them with dowries, we do not grant dowries to the younger daughters and then divide the estate. They all get equal. Why is that? Hmm? I don't know. Neither do I. Okay, the following rules apply when a man has died, leaving two daughters and a son. The older daughter receives a tenth of the estate as a dowry, but before the younger daughter had collected her dowry, the son died without leaving any heirs. The two sisters inherited the entire estate now, right? In this situation, the younger sister is not entitled to a tenth of the estate. Instead, the entire estate is divided equally, but the older daughter is granted the tenth she had received previously. Instead, the entire estate is included, but the oldest is granted the tenth of she. In other words, she gets it. It's included. I mean, she got it already. Yeah. When a man gives an order at the time of death, do not give my daughters a dowry from my estate. His words are heeded. The rationale is that a dowry is not one of the provisions of ksuba. Remember, ksuba is a contract, right? Marriage contract, right? And in that marriage contract is not a dowry, right? The rabbis added this, that there is a responsibility to that, but it's not an inherent responsibility based on the ksuba. So therefore, there isn't an inherent responsibility that he has to provide dowry. He has inherent, the ksuba has an inherent responsibility to sustain, right, after his passing, the children, to sustain them. But dowry is different. Perhaps I'm just a thought of mine. Why dowry is different is because, as we saw, that if the father said, "I'm not going to give," take her the way she is, so then the husband to be, the groom, he has a responsibility. In other words, it can fall on someone else's responsibility. Ideally, the proper way is the father. Okay. The following rules apply when a man dies, leaving a widow and a daughter. It has already been explained that the support of the man's widow takes precedence over the support of the daughter. He first has the widow and then the daughter. Similarly, if the daughter marries, she is not entitled to collect the tenth of the estate because the obligation is the support of the widow. So she doesn't get from the dowry. She doesn't get because he has an obligation to her. Right? Don't they all have widows? Huh? Don't they all have widows? What do you mean? Have widows when they die? I mean, most men have. Yeah. So what's the question? I'm not clear what the question is. Even a daughter dies after she marries, her husband is not entitled to inherit the dowry that she should have been given. The entire estate is considered to be in the possession of the widow so that she can derive her sustenance. Right. So that's right, because that's based on the ksuba, on the marriage contract, right? That he has to sustain her. So that takes priority where the dowry is secondary. Even if she died, this daughter who married, right, this guy doesn't have anything that he can take from the widow, right, from the mother-in-law. What does that mean? When somebody dies, they leave a widow behind. Well, unless she died beforehand, right? I mean, just giving a scenario of what, Number 12, when an orphan girl is married off by her brothers or her mother as a child with her consent, or in other words, she's orphaned from her father or from both in the first instance. In the second, the mother is giving her off as a child, right? A child bride before 12, with her consent, and she is given 50 or 100 zuz as a dowry. She's entitled to collect the dowry that is due her, according to the estimation of the father's desire of her, or the tenth of the landed property, or of his estate, from them after she attains the age of majority. So they were going to give her a small amount, but it's due to her, and it's only comes to her by the age of majority. Right. Yeah, I'm not certain why exactly, because I guess you're not, you really shouldn't. You could marry off your daughter before the age of majority. The sages didn't like that. I mean, reasoning for that, or a reasoning for that is that, that someone will take care of her and provide for her if you're in a destitute situation, right? But, or for whatever other reason. But when she reaches the age of majority, then she's going to get her 10%. This applies even if her brothers did not provide her with sustenance, and even if she did not object in the time of the wedding. But the minor is not capable of making an objection in court, right? It was a minor, didn't and wasn't being sustained, not rightfully, or whatever. I'm not, yeah, how did that happen exactly? Okay, we have to see the following halacha. When when a daughter marries after she reaches majority, when she's a naira or as a boigeres, naira is 12 to 12 and a half. Boigeres is from 12 and a half onwards, and does not demand her dowry. She forfeits her dowry. Remember, we said it's not an inherent obligation. So she's got to ask for it. She doesn't. She forfeits it. If, however, she processes at the time of the marriage, she may collect her due whenever she desires. So, right, in other words, she didn't ask for it right away. She got engaged and she didn't ask for it right away. But at the time of marriage, she did. So it means something that's coming to her. And she can get it even later on, even after being married. A further point must be considered when she reaches the age of Bagrus, 12 and a half, and remains in her father's house, regardless of whether she reaches Bagrus after his death, or he died when she was already reached the age of Bagrus. If her brothers have already ceased providing her with sustenance, which is their prerogative, as we've explained, and the girl remains silent and did not demand dowry, she forfeits the dowry. If she protests, she does not forfeit the dowry. So the brothers who inherit the father, right, and have responsibility for sustenance and dowry to the sisters, right, the daughters of the deceased father, they only have that responsibility until 12 and a half or 12. I don't know if it's 12 or 12 and a half for sustenance. Second, just want to take a look at something. So it seems to me, the way I understand over here, in particular back in the day, uh, you know, they got married or engaged, at a can be at a very young age, right? Age of majority. I guess this way they were taken care of. So sustenance is only until that time. And okay. I don't think I mean, I'm not, in other words, we're talking about obligation. After that time, today, I don't know, I think today there's still an obligation. Not exactly how that works. Okay. If her brothers have already ceased providing her with sustenance, so even if she didn't get sustenance, right? Yeah, she's still entitled to the dowry, right? She can still collect it. Okay. Further point is that when she reaches Bagras, remains in father's house, regardless of whether she reaches Bagras. If the brothers are already ceased providing her with sustenance, which is their prerogative, when the girl remains silent and did not demand dowry, she forfeits. So she has to ask for it, even though she didn't get sustenance. But that doesn't take away the dowry that is still coming to her, right? If, however, the brothers had not ceased providing her with her sustenance, although she reached Bagras, she is not considered to have forfeited her dowry as long as they continue to provide her for sustenance, even though she did not protest. Right? She can claim that she did not demand her dowry because the brothers were supporting her, although they're not obligated to do so, and she was not yet married. So she wasn't married yet. Why didn't she protest? I want to, put aside for my dowry. I could get married anytime now. So put it aside. She didn't protest and say that or, make that demand, right? Why? Because the brothers were still sustaining her, which they didn't have an obligation, but uh, they were proper brothers. So they took care of her, right? She wasn't married yet. So there was someone had to take care of her. So the brothers took care of her, right? From dowry or no. They're sustaining not from dowry. Dowry is for getting married, right? This is from the estate. No, it's from the estate of the father, right? Okay. Which they are handling. So she didn't protest and say, give me my dowry because they're going beyond the letter of the law and taking care of her in the right way. And so therefore she didn't want to make a demand for something more at that point because she wasn't engaged anyways, right? So therefore the fact that she didn't say anything doesn't mean at all that she forfeited her dowry. Following the rules apply when a man stated, whether while making an oral will before death or while healthy, that his daughter should be given a specific sum amount as a dowry, and this sum should be used to purchase land and property, and then died afterwards. When the money in his possession is in the possession of a third party, and the daughter states, "Give me money to my husband, and let me do with it and let him do with it as he desires." Third party should do as follows, right? Because the father said to give it to the daughter, right, not to the son-in-law. If the daughter has reached the age of majority and she is married, she's granted this prerogative because she can make her own choice, right? If she was past majority but merely consecrated, the third party should follow the instructions that were given. Because consecrated meaning, really, the first part only given the ring, so they're married to each other, but they're not living together. So the husband doesn't have responsibility to sustain her yet because she's living in her father's home. Here, the father died, though, right? So the brother's, right? So the third party is not going to give it to, because the only reason they would give it to the husband is because he's taking the husband sustaining her, but the husband isn't sustaining because this is the only kiddushin, right? They're not setting up, they didn't set up home yet. And if she's a minor, even if she's already married, her request is not heeded. Instead, the third party should carry out her father's instructions. When she'll reach the age of majority, that she will get landed property. Wow. Powerful stuff. All right, folks.
Thank you, Rabbi.
3:30.
Thank you, Rabbi.
Have a good day, everyone.
Thank you. Bye-bye.
Thank you.
Bye-bye.
Hey, thank you, Samsung.
Bye, Rabbi.
From Texas.